You know, being broke isn't a crime. I think we've all been in a tight spot at some point.
Hmm.
But there's a huge legal line between actually having $0 and pretending to have $0 just to dodge a bill.
That's the key word right there, pretending.
Exactly. And today we're diving into that line, specifically Article 314 of the revised Penal Code, which is all about fraudulent insolvency.
Right.
Our mission here is to figure out, when a bad situation crosses over into a criminal act and why it's often so difficult to make these charges actually stick in court.
It's a really specialized area. I mean, the
Mhm.
law is essentially trying to read a debtor's mind to prove their intent.
Yeah, and that word absconding that's in the law, it's a bit misleading.
It is. Most people hear absconding and they picture someone grabbing a suitcase of cash and jumping on a plane to a non-extradition country.
Right, the big dramatic escape.
But in the legal world, the person usually stays put.
Hmm.
They're still there. It's the property that absconds.
Ah, okay. So the person is still sitting in their office, but suddenly their name isn't on the deed to the warehouse anymore.
Exactly. Or the title to the luxury car. They've sold it to, say, their brother-in-law for practically nothing.
You see that all the time, but Article 314 says that's not just shady, it could be a crime. But the law sets a really high bar, right? There are, what, three specific elements that have to line up?
Precisely three. And if even one is missing, the case falls apart. The first one is all about the clock. It's about timing.
Okay.
You have to be a debtor, obviously, but your debt must be due and payable
So, not a future debt, a debt that's on the table right now.
right now. If you move your assets around months before a bill is legally owed, well, you might be looking at a loophole. The law is looking for that moment when the creditor comes knocking and you decide to make your assets vanish.
So, if I see someone offloading their real estate the day after they lose a major lawsuit, that's a huge red flag.
That's your red flag.
Yeah. Which brings us to the second element, the act of absconding itself, these fictitious transfers. But here's what I always wonder. How do you prove a sale is fake? On paper, it looks legit.
That is the challenge. And you're looking for the behavioral smoking gun? If the debtor sells their house but never moves out,
Or they sell the company car but still hold on to the keys and pay for the gas?
you've got it. The law looks for those transfers where ownership changes on a document, but control, the actual use and benefit, never really leaves the debtor's hands. It's just a paper shield.
Okay, so we have a debtor with a current bill and a very suspicious transfer. But even then, you might not have a criminal case. This third element, actual prejudice, that's where it gets really specific.
This is the one that trips up a lot of cases. It's the sting requirement. The law doesn't just care if the debtor intended to annoy you. The creditor has to suffer actual financial harm.
So let me get this straight. If a debtor hides $1 million in an offshore account, but they still have a factory and a fleet of trucks here that I can seize to pay off the debt,
Then there's no actual prejudice under Article 314. You haven't been harmed in the eyes of this specific law because you can still get your money.
wow. So the crime isn't hiding assets. The crime is hiding assets and leaving the creditor with nothing to collect.
The Vanishing Act has to be the direct reason you aren't getting paid. It really seems like the law is designed to protect the collection process itself, not just the creditor's feelings.
Which all comes back to malice, malicious intent. It's not a crime to be bad at business or make a bad investment.
No, of course not. That happens. This is about a calculated effort to defraud. It's a deliberate strategy.
When you see a debtor who was flush with cash suddenly claim insolvency the moment a judgment is at their door, that's what you're looking for.
That's the pattern. For the creditor, it means you have to look past the "I have no money" excuse and start digging into that paper trail. Where did the property go?
So for this to stick, you need that perfect trifecta. A current debt, a disappearing asset, and a real financial sting.
Get all three, and you have a potential criminal case. Miss one, and it's likely just a civil headache.
So knowledge of this really is the best defense for a creditor. Understanding these pillars helps you spot the difference between someone who's genuinely struggling and someone who's performing a legal stunt.
Absolutely.
Okay, before we wrap up our exploration into Article 314, I want to leave everyone with a final thought to chew on. Let's say a debtor hides $1 million asset, but still has enough other property to pay you back. Except that other property is tied up in 5 years of litigation in another country. Is that actual prejudice?
Ooh, but that's a good one.
Does the law only care if they leave you with absolutely zero, or is making it practically impossible to collect your money? Is that enough to count as a crime, something to mull over?
Have you ever worried that someone who owes you a bunch of money might just disappear with it? Well, today we're going to dig into what happens when a debtor's empty pockets aren't just a case of bad luck, but a calculated crime. We're talking about fraudulent insolvency. I mean, think about it. It is an incredibly frustrating situation, right? You're owed money, the payment is due, and then all of a sudden, the person who owes you claims they're completely broke. It's like their assets have just vanished into thin air, and you're the one left holding the bag.
But here's the thing. This might not be just a simple case of misfortune. If that little vanishing act was intentional, the law actually has a specific name for it: fraudulent insolvency, and it's a crime defined right there in Article 314 of the Revised Penal Code. So how does the law tell the difference between someone who is genuinely, truly unable to pay their debts and someone who is criminally hiding their assets? Well, it all comes down to three key ingredients.
Okay, to prove this crime, a prosecutor has to establish three things, and they have to prove them beyond a reasonable doubt. First, that a debt actually exists. Second, that the debtor absconds with their property. And third, that this action causes real, tangible harm to the creditors.
Let's start with the absolute foundation of the entire case, the debt itself. Pretty straightforward, right?
So the crucial point here is that we're not talking about some future promise or a casual, "I'll pay you back later." The crime kicks off with a person, the debtor, who has existing obligations that are officially due and need to be paid to a creditor. It's a real debt on the books.
All right, this next part, this is where the real deception happens. It's all built around one single powerful legal term, and its meaning is probably way broader than you think. And here is the key legal twist you have to understand. Absconding is not about the person disappearing. No, it's about their property disappearing. The crime is the act of hiding or removing assets just to keep the creditors from getting what they're owed.
This means a person can abscond without ever even leaving their house. They could literally hide valuable items, stuff them in a storage unit somewhere, or even transfer the ownership of a house or land through a completely fake sale. The crime is in the concealment, not the person physically running away.
And there's a Supreme Court case, People v. Tan Diong, that gives a perfect example of this. A debtor faked the sale of their property just to get it out of their name. That simple act of hiding the asset through a bogus transaction, in the eyes of the law, that is absconding.
But just hiding the assets isn't quite enough to complete the crime. The prosecution has to prove one final critical element: that the creditor was actually harmed by what the debtor did.
This is called actual prejudice, and it means exactly what it sounds like. The court needs to see real, measurable financial damage. It's not about what someone's bad intentions were, it's about the actual harm that was done to the creditor's ability to collect their money.
This case law makes such a crucial distinction. Hiding one asset isn't automatically a crime. So for example, if a debtor sells a car, but they still own a house that's valuable enough to cover the debt, then the creditor hasn't been prejudiced in the eyes of the law.
And this is a really key distinction. The crime is only completed if the debtor's act of hiding property is what directly prevents the creditor from being paid. If there are other assets still available that could satisfy the debt, then that element of actual prejudice, it might not be met.
So underpinning this entire thing is the debtor's mindset. The law isn't just looking at the action, but the intent behind it. It's looking for something called malice.
Malice is just the deliberate intent to defraud somebody. But, and this is a big but, this intent can be challenged. Like in the case of People v. de Guzman, it was shown that if a debtor sells a property but then turns around and gives a portion of that money to the creditor, that can actually demonstrate good faith and cancel out the element of malice.
So let's put it all together. Once you understand these elements, you can start to see that very, very fine line between someone who's just experiencing genuine financial hardship and someone who is committing a calculated financial crime.
It's also super important not to confuse this crime with a violation of the insolvency law. The key difference here is all about timing. Fraudulent insolvency under Article 314 happens before any official insolvency or bankruptcy proceedings even begin. The other crime, that happens after those proceedings are already underway.
And just a final point of clarification. Anybody can commit this crime. You absolutely do not have to be a merchant or a business owner. The law applies to any debtor, though I should mention, being a merchant can lead to a more severe penalty.
So, the key takeaway is this. When a debtor's assets seem to just vanish, don't just assume it's bad luck. The law gives us a clear three-part test for malice.
And it forces us to ask a pretty critical question, not just in a courtroom, but in our own financial dealings. Where do we draw the line between misfortune and outright deception?
Welcome back to the deep dive. I was looking through the stack of documents we have for today, and I had this very specific, very visceral reaction.
Oh, yeah.
Yeah, it's that feeling you get, and I think everyone listening knows exactly what I'm talking about. When you walk out to your mailbox, you open that little metal door, and amidst the junk mail and the pizza flyers, you see an envelope.
Not just any envelope.
No, not just any envelope. It has that specific little plastic window on the front, maybe a red stamp that says urgent or final notice.
It's the universal color code for panic.
Exactly. The universal symbol for you owe us money and we are tired of asking nicely. And I think for most of us, debt is this heavy, sort of low-hanging cloud that follows us around. It's stressful, sure. But today, we're going to look at what happens when that cloud turns into a full-blown hurricane. We are looking at the moment where I can't pay right now transforms into I am not going to pay and I am going to make sure you never, ever find my money.
And that is a fascinating pivot point in the legal world. You're describing the boundary line where civil law, which is basically just people arguing over broken promises and, contracts, bleeds into criminal law.
Where the state steps in.
Where the state steps in and says, okay, that's enough, now you're going to jail.
And that is a terrifying line to cross, and I think a lot of people might cross it without even realizing they've done it. So we are opening up a file today on crimes against property, specifically Chapter 5.
The legal term is culpable insolvency.
Right. But the absolute star of the show today, the thing we are going to dissect piece by piece, is Article 314 of the Revised Penal Code, Fraudulent Insolvency.
It sounds incredibly dry, doesn't it? Fraudulent insolvency. It sounds like something that happens in a boardroom with guys in gray suits shredding documents late at night.
Totally.
But when you actually peel back the layers of these court cases we have in front of us, it isn't dry at all. It's actually a high-stakes, almost primal game of hide and seek.
High stakes is right. So here's the mission for this deep dive. We are going to unpack the statute, but I want to do it by testing the boundaries. I want to play a game of, can I get away with this?
Okay, I like this.
Right. If I owe $1 million and I see the bank coming, the walls are closing, and what are my options? Can I sell my house to my brother for $1?
A classic move.
Can I bury my gold bars in the garden? Can I sign my car over to my dog?
You can try. But as we're going to see from the sources, and we've got some great ones here, the law is surprisingly good at seeing through your magic tricks. It's been dealing with people who don't want to pay their debts for centuries. It has seen, like, every trick in the book.
That's what we're here to find out. We have an outline today that covers 3 main acts in this little drama. First, we have to define the debtor. And I was surprised to learn it's not as simple as just someone who owes money.
Not at all.
Second, we're going to look at the concept of absconding, which I learned from these notes does not mean what I thought it meant.
Yeah.
Not even close.
That's the one that trips everyone up.
And third, and this might be the most important safety valve in the whole law, the concept of prejudice.
Ah, yes, the no harm, no foul rule. That one is the real game changer. It's what keeps a lot of regular people out of prison, even when they've done something that looks, technically shady.
So let's stop stalling and start diving. Part 1, the offender and the obligation.
Let's set the stage. For a crime to happen under Article 314, you need a very specific type of person. The law calls this person the debtor.
Okay, but debtor is a pretty broad term. I mean, if we go out to lunch and I forget my wallet and you cover me, technically I am your debtor until I Venmo you the $20.
Technically, yes.
If I don't pay you back by tomorrow, am I a criminal? Can you have me arrested for fraudulent insolvency over a sandwich?
No. And this is where we have to be really, really precise with our language. The source material, our syllabus here, it defines the offender as someone who has due and payable obligations.
Due and payable. Okay, those seem like standard contract words, but I get the feeling they are doing a lot of heavy lifting here.
They're doing all of the lifting. Think about the biggest debt most people have. A mortgage. You might owe the bank, say, $500,000 on your house. Technically, you are a debtor. You have this massive obligation.
Right.
But is that entire $500,000 due and payable right now, this second?
No, of course not. Only this month's payment is due. The rest is spread out over the next 30 years, hopefully.
Exactly. So you're not the right kind of debtor for this law. Not yet. The law is looking at the end game. It's for when the timeline has run out. The bill hasn't just arrived. It's past due. the final notice has been sent.
So unless you've triggered what's called an acceleration clause, where the bank demands the entire balance immediately because you've defaulted, you aren't the kind of debtor this law is targeting.
Precisely. The obligation has to be mature. If I lend you money and we sign a contract that says, pay me back in the year 2030, and I see you selling your car today, in 2026, I can't call the police.
Because you don't have the right to that money yet. I haven't broken my promise.
Correct. You can sell your car. It's your car. I can't claim you're hiding assets from me if I don't have a legal right to seize those assets yet anyway. The law protects your freedom to do business right up until the moment you actually default on a due obligation.
That's a crucial distinction. It's the difference between having a bill sitting on the kitchen counter that you plan to pay on Friday and having a collection agent pounding on the front door with a court order.
That's a perfect analogy. The clock has to have run out.
That makes sense. It stops a nervous creditor from, controlling your entire life just because you owe them money way off in the future.
It does. It maintains a balance of power.
But there is another misconception about the debtor that popped up in the notes. It's something you called the merchant myth.
Oh, yes. This is a classic law school trap. It catches students all the time.
The assumption, and I'll admit I kind of assume this too, is that insolvency is a white-collar crime. It's a business crime. It's for CEOs, corporations, merchants. Regular people just go broke. They don't go insolvent. It sounds too official.
And the source material, and it's citing the legal scholar Ray's here, just shuts that down immediately. Being a merchant is not an element of the crime.
So just to be crystal clear, a school teacher, a plumber, a podcast host, a nurse, if any of us have a due debt and we, pull a fast one to hide our assets, we are on the hook for this.
100%. The law applies to any person.
Yeah.
The nature of your employment is completely irrelevant. The only thing that matters is the nature of your action. Did you have a due debt, and did you hide property to avoid paying it?
Okay, so that's clear. But the source does add a little bit of nuance here. It says that while being a merchant isn't required to commit the crime, if you are a merchant, it raises the penalty.
Yes. If you are in business, the punishment is harsher.
Why? Why is that? The text doesn't explicitly give the philosophy, but if we had to sort of connect the dots, does the law just hate business people?
I don't think it's hatred. I think it's about expectation. Let's speculate based on the general principles of commercial law. Merchants, businesses, they're the engine of the economy. They operate almost entirely on credit and trust.
Right. Supply chains, net 30 terms, lines of credit from the bank, it's all based on promises.
Exactly. The whole system runs on the belief that people will pay their bills. Now, if a regular guy doesn't pay his friend back, it's bad. It ruins a friendship. Maybe it causes a localized problem. But if a merchant doesn't pay their supplier or hides assets from a lender,
it ripples.
It ripples through the entire supply chain. That supplier can't pay their supplier. The lender becomes more cautious and stops giving loans to other businesses. It breaks the public trust in the commercial system.
That makes a lot of sense. It's like we hold you to a higher standard because you are playing the game professionally. You are expected to keep books, to have records, to be transparent.
Right. Society gives merchants certain privileges, and in return, it expects a higher degree of integrity.
So if you are a merchant and you engage in fraudulent insolvency, you aren't just stiffing a creditor. You are, in a way, attacking the integrity of the market itself.
So the hammer drops a little harder.
Yeah.
But the takeaway for you listening is, don't think you are safe just because you don't own an LLC. If you owe money that's due, you are in the game.
Okay, so we know who the offender is, anyone with a bill that is due right now. Now let's get to the fun part, the action movie part, the crime itself. The text says the offender must abscond with his property.
Abscond. It is a great word. It sounds so old-fashioned, like something out of a Dickens novel.
It really does. And honestly, when I hear abscond, I have a very specific image in my head. I'm picturing a guy in a trench coat, stuffing bundles of cash into a leather duffel bag, looking over his shoulder, and jumping on a midnight train to Paris.
The Midnight Run scenario. The classic fugitive on the lam.
Yes. Or maybe a speedboat to a non-extradition country. That is what absconding means, right? Running away. Getting out of Dodge.
In the dictionary. Sure. But in Article 314 of the Revised Penal Code, no. This is where the legal definition completely flips the script on the common, everyday definition. It's a total curveball.
Okay, explain that. Because the source cites a really important case, People versus Chongchuli-Longobo. What did the court decide there? What was the big question?
The court had to decide, does absconding mean physically running away? or physically hiding the object, and said emphatically, no, it does not require that.
So you can abscond with something while you're sitting on your couch at home.
You can abscond with something while standing right next to the creditor, looking them straight in the eye. Because in this context, absconding doesn't mean moving the person, and it doesn't even necessarily mean moving the object.
It means moving the ownership.
That's it. You nailed it. It's about making the ownership vanish.
This is the part that really bent my brain a little bit when I was reading the notes. The syllabus says that even real property can be the subject of fraudulent insolvency. And for those who don't speak lawyer, real property means real estate, land, buildings, things you can't move.
Correct. Immovable property.
So walk me through the physics of this. How do you run away with a warehouse? I can't put a warehouse in the trunk of my car. I can't bury a plot of land in the backyard. If absconding required physical concealment, it would be literally impossible to commit this crime with real estate.
Exactly. And if the law was that literal, every debtor with a mansion or a factory would be completely safe. But the law is much, much smarter than that. It recognizes that you can hide a building in plain sight by using paper.
Paper?
You make the ownership disappear, you make the asset legally invisible, or at least legally untouchable to the creditor who's chasing you.
This brings us directly to the sham sale. This was the core of another case in our stack, People versus Tandion.
A classic case. This is basically the blueprint for how people try and, importantly, fail to cheat the system.
So let's role-play the mechanics of a sham sale. I owe you $1 million. It is due today. I have a warehouse, and it's worth $1 million. I know you are going to sue me and get a court order to take the warehouse. I don't want that to happen, so what do?
You find a conspirator, someone you trust. It's your cousin. You go to a lawyer's office, and you draw up a deed of sale. It looks completely official. It has a notary stamp. It follows all the formatting rules.
It looks legit.
Totally legit. It says, I, the host, hereby sell this warehouse to my cousin for the sum of 1 million pesos. You sign it, your cousin signs it, you file it with the Registry of Deeds.
Okay, so now if anyone, you, the creditor, a judge, anyone looks at the public record, the warehouse belongs to my cousin.
Exactly. So when I, your creditor, go to court to seize your assets, my lawyer pulls your file and I see nothing. You own nothing of value. The warehouse is gone. In the eyes of the law, you have absconded with the warehouse by transferring the legal title.
But wait a second. If I actually sold it, and my cousin gave me 1 million pesos, then you can just seize the cash from my bank account. The problem's solved.
Ah, but that's the catch. This is where the crucial legal term, fictitious consideration, comes in.
Fictitious consideration. That sounds like a polite, lawyerly way of saying fake money.
It is essentially lawyers speak for a lie. In contract law, consideration is the value you give in exchange for what you get. Usually it's money. Fictitious consideration means the contract says money changed hands, but in reality, it didn't.
So your cousin never actually gave you the 1 million pesos?
Maybe he gave you nothing. Or maybe he wrote you a check, you showed it to the notary to make it look real, and then you tore it up 5 minutes later in the car.
Or I give him the cash under the table, he hands it back to me officially in front of the lawyer, and then I take it right back.
Exactly. It's all theater. It's a lie on paper. The goal is to create a false history. It creates a paper reality that is designed to defeat the actual reality.
And in the actual reality, I'm still the one using the warehouse. I still have the keys. I'm probably still collecting the rent from the tenants. But in the paper reality, the one the court sees initially, I'm a pauper with no assets.
You've put the asset beyond the reach of your creditors, which is the key phrase the law uses.
That is devious, and it really expands the definition of theft or fraud in my mind, because usually we think of theft as taking something that isn't yours. This is about keeping something that is yours but pretending it isn't so you don't have to give it up.
It's theft by dissociation. You are severing the legal link between you and your property so that the debt, which is like a magnet, cannot attach to it.
And the court in Tandiong looked at this whole song and dance and said, nope, we know what you're doing.
They did. Over the years, the courts have developed what they call badges of fraud. They look for clues. Is the price suspiciously low, like $1? Is the buyer a close relative? Did the seller continue to live in the house or use the property after selling it?
Ah, so they look for signs that the reality doesn't match the paper.
Exactly. If the answer to those questions is yes, the court just cuts right through the paper reality and says the sale was a sham.
So just finding the paperwork isn't enough to trick a judge.
Not a good one, no. They've seen this play before.
Okay, so we have the debtor with a due debt, We have absconding, which is hiding the ownership, usually through a sham sale. Now we get to part 3. And this, to me, is the most surprising part of the research. Even if I do all that, even if I fake the sale and lie to you, I might still be innocent of this specific crime.
This is where the plot thickens, absolutely. We have to talk about the third element, prejudice.
And we don't mean prejudice in the social sense. We mean legal prejudice, harm, damage.
Actual financial injury to the rights of the creditor.
Yeah.
The source cites People versus CD Home. This is a critical case for anyone who is worried about, asset protection or making mistakes when things go south.
So what happened in Siegejang? What was the big ruling?
The ruling established a principle that I like to call the no harm, no foul defense. It basically says, it doesn't matter how shady you were, it doesn't matter if you lied, it doesn't matter if the sale was fake, if the creditor wasn't actually prejudiced, meaning if they weren't actually prevented from collecting their money, there is no crime under Article 314.
Hold on. That seems counterintuitive. How can I lie about selling my house, hide it from you, and not prejudice you? Isn't the lie itself the harm?
Not in the eyes of this specific law. Let's construct a scenario to make it clear. You owe me $100,000. You panic. You fake sell your vacation home. Let's say it's a cabin in the woods worth $100,000 to your sister to hide it from me. You clearly have bad intent. You're trying to cheat me.
Okay, I am the villain in this story. Got it.
You are acting like a villain, for sure. But let's say my lawyer does some digging, and the court looks at your finances and realizes, wait a minute, the host has $500,000 sitting in a perfectly normal Bank of America checking account. And that account isn't hidden. It's right there. It's in your name, under your Social Security number. I, the creditor, can easily go to court, get a writ of garnishment, and take my $100,000 from that account.
So because you have another easier way to get paid.
My inability to seize the cabin is irrelevant. I haven't been prejudiced. I can still get my money. The law says Article 314 applies only when the debtor has concealed property, and that concealment leaves the creditor with no other recourse.
That implies a sort of hierarchy of assets, doesn't it? Like the creditor has to go after the easy stuff first.
It does. It implies that the crime of fraudulent insolvency is a crime of last resort. It's a crime of creating a total dead end. If you just create a detour, you hide the cabin, but the road still leads to payment via the bank account, it's not this specific crime. You might be in trouble for something else, maybe, but not this.
Wow. That puts a massive burden on the creditor. They have to prove a negative. They have to prove that there's nothing else.
Essentially, yes. The prosecution, on behalf of the creditor, has to prove to the court, we looked everywhere. We turned over every rock. We checked the banks, the stocks, the cars. And because he hid this one specific thing, we are left with zero. We are prejudiced.
So let's play devil's advocate here. If I am a really smart, really cynical fraudster, does this mean I should just leave a little bit of money visible to avoid jail time?
Go on, I'm listening.
Okay, say I owe $1 million. I hide a $10 million building through a complex web of shell corporations, but I leave a 2010 Honda Civic in the driveway and, I don't know, $5,000 in a checking account. Can I stand up and tell the prosecutor, hey, look, I have assets. You aren't totally prejudiced. Take the Honda.
That is a very dangerous game.
Well,
but logically, you have a point. If the assets you left visible are enough to satisfy the debt, you are definitely safe from this charge. If they are not enough, well, then the creditor is still prejudiced for the remainder.
Okay. So I can't just leave a penny and claim solvency.
No. If you owe $1 million and you hide the $1 million and you leave $5,000 visible, you're still insolvent for $995,000. The creditor is still prejudiced. But the principle remains. The creditor has to exhaust your other visible assets first.
Why does the law do that? Why give the fraudster a break just because they were incompetent at hiding everything? It feels weird.
I think it goes back to the purpose of the law. This isn't a morality police statute designed to punish every lie. It's a property protection statute. If the creditor's property rights, their right to get paid, aren't actually destroyed, the criminal law stays out of it. It assumes the civil courts can handle the rest.
It feels like the law is saying, don't waste the prosecutor's time and the taxpayer's money on a jail sentence if you can just garnish his wages or seize his bank account. It's about efficiency.
Exactly. Criminal law is the nuclear option. You don't nuke a guy who has a visible, garnishable bank account. You just take the money. It's much simpler.
That is surprisingly practical. It strips the emotion out of it. Like, I don't care that you lied to me. I just want my money.
The law tries to be practical even if the people involved are not.
So we have the debtor, we have the absconding, we have the prejudice. Now, Let's talk about what is going on inside the offender's head. Part 4. The mental state.
The mens rea, the guilty mind.
The outline uses the word malice.
Yes. Fraudulent insolvency is an intentional crime. This is key. You cannot accidentally commit fraudulent insolvency. You can't just be bad at math or forget you owned a house somewhere. You have to have malice. You have to intend to cause the prejudice.
But here's the problem I always have with intent crimes. It feels so squishy. How do you prove what's in someone's head? I can always just lie on the stand. I can stand up in court and say, Your Honor, I didn't mean to defraud anyone. I was just reorganizing my portfolio for tax purposes.
That is the standard defense. I'm not a criminal, I'm just an idiot. Or I'm not malicious, I'm just a bad businessman.
Right, the incompetence defense. So how does a court see through that?
Well, actions speak louder than words. The syllabus cites a great case for this, People versus de Guzman, which gives us a fascinating playbook on how a defendant can disprove or negative the existence of malice.
Okay, so what happened in de Guzman? How did the defendant prove he wasn't malicious?
In that case, the defendant did something that completely neutralized the argument that he was acting with malice. He sold the property, yes. He disposed of the asset the creditor was hoping to get, but then he took the money from the sale and paid the creditor part of what he owed.
Wait, say that again? He sold the very property that the creditor wanted,
Yes.
but he took some of the cash from that sale and handed it over to the creditor.
Correct. And the court looked at that and said, essentially, a thief doesn't share the loot with his victim.
Huh. That is surprisingly logical. It's very simple, but it makes perfect sense.
It shifts the entire narrative. If I hide all my assets and give you nothing, the narrative is I am stealing from you. It's an act of concealment and evasion. But if I sell my assets, even quickly, even cheaply, even to a friend, but I then turn around and hand you a check for 20% or 30% of the debt and say, look, I'm in trouble. This is all I can get right now. Please take this.
The narrative becomes, I am managing a crisis. It turns a crime into a tragedy. I'm broke. I'm trying. Here's a little bit to show I'm not running away.
Exactly. It shows good faith. And good faith is like kryptonite to a fraud charge. It demonstrates that your intent wasn't to leave the creditor with nothing, but rather to liquidate assets to pay them something.
So practically speaking, if you are listening to this and you are drowning in debt and you find yourself selling things off in a panic, the single smartest thing you could do is take some of that money and pay your creditor something, anything. That act might be the magic shield that keeps you out of handcuffs.
It is the difference between being a struggling debtor and a criminal fraudster. It signals that you recognize the debt and are trying to address it, even if you can't pay it all. Malice is about the intent to evade the debt entirely, to make it uncollectible.
This is really painting a picture of a law that is quite reluctant to put people in jail for debt. It has all these hurdles. The debt has to be due. You have to be totally out of other assets. You have to have totally stiffed the creditor, not even paid a part. You have to have hidden the ownership.
The law generally recognizes that business is risky. People fail. Life happens. Companies go under. The law doesn't want to criminalize failure. It wants to criminalize cheating. And there's a massive, massive difference between failing and cheating.
Speaking of cheating, let's talk about who exactly gets in trouble when the cheating happens. We talked about the offender, but what about the people around the offender? Part 5, the specificity of the victim and the offender.
Right, this is a good one. We are going back to People versus Tandiong for this, but looking at a different angle of the case. This case involved a husband and a wife.
Okay, so the husband owed the money. He was the official debtor on the loan.
He was the one who signed the contract, yes.
But the wife, she was there too. The facts say she co-signed the sham deeds. She helped him move the assets on paper. She was present and participating.
She was involved, no question.
To me, she sounds like the getaway driver. She helped commit the crime. She should be guilty too, right? An accomplice.
Morally? Maybe. You could certainly argue she was an accomplice to the dishonesty. But legally, under this specific statute, the court asked a very precise question. Was the wife guilty of fraudulent insolvency?
The verdict.
No, she was not.
Why? That feels like a giant loophole. She helped hide the money.
It does feel like that, but it's because of the strict definition of the offender that we talked about at the very beginning. Remember what we said? The offender must be a debtor.
Ah.
The wife did not owe the money.
It was the husband's debt. She never signed the original loan.
Correct. The creditors being cheated were his creditors, not hers. You cannot be guilty of fraudulent insolvency regarding a debt you do not personally owe.
That is a massive technicality, but a hugely important one.
It's a protection of individuality under the law. even within a marriage. Unless you specifically sign that promissory note as a co-maker, or unless the specific property regime in your jurisdiction makes you automatically liable, you are a separate legal entity regarding that specific obligation.
Because you can't be insolvent on a loan you never took out?
Yeah.
You can't be in a state of insolvency if you're not obligated to pay in the first place?
Precisely. You can't default on a loan you never signed.
So she just walks free.
On the charge of fraudulent insolvency, yes. Now, a big caveat here. If they forged documents, she might get hit with falsification. If they lied under oath in court, that's perjury. There are other crimes she could be charged with. But she cannot be an insolvent debtor if she isn't a debtor.
That really protects the spouse who might just be trying to keep the peace at home, sign this, honey. Okay, sure. It protects them from being dragged into a criminal conviction for a debt that isn't theirs.
It recognizes that liability is personal. You don't inherit criminal liability just by wearing a wedding ring.
Okay, we have unpacked the elements. We know who the players are, but there's one final piece of the puzzle in our source material. Section B, the distinctions. Fraudulent insolvency under Art. 314 versus violation of insolvency law.
Right. This is where things can get confusing because the names are so similar. You have insolvency as a crime in the penal code, which is what we've been talking about this whole time. And then you have the insolvency law, which is a whole separate set of regulations handling formal bankruptcy proceedings.
It sounds like the same thing. I'm insolvent. I'm bankrupt. Tomato, tomato. What's the difference?
It does. But the source, citing Reyes again, says there is no inconsistency between them. They just apply at different times. It's all about the timing.
The timeline factor.
The timeline factor. To understand this, imagine the life cycle of a failing business or a failing personal finance situation as a sinking ship.
Okay, I'm on the Titanic. I've hit the iceberg.
Phase 1. The ship has hit the iceberg. It is taking on water. You, the captain, who is also the debtor, are panicking. You're running around the deck, throwing furniture overboard, maybe trying to hide the ship's gold in a lifeboat so you can grab it later. This is the Wild West phase. No one is in charge but you.
And the sheriff hasn't arrived yet. The creditors are just other ships on the horizon shouting at me.
Exactly. If you hide assets during this phase before any court has stepped in to formally take over, that is Article 314. That is fraudulent insolvency under the Penal Code. You are cheating your creditors directly in a private battle.
Okay, so when does the other law kick in?
Phase 2. The distress signal goes out. The Coast Guard, that's the court, arrives. They board the sinking ship. They say, "Captain, step away from the wheel. We are taking over." This is the formal institution of insolvency proceedings, or what we call bankruptcy.
Right. A trustee is appointed. The court takes control.
Yes. Once the court takes over, the assets technically don't belong to you anymore in the same way. They're in custodia legisis under the jurisdiction of the court or an assignee appointed by the court.
So the game changes completely.
Totally. If you try to hide assets now after the court has stepped in and taken control of the ship, you aren't just cheating the creditor anymore. You are disobeying a direct order from the court. You are violating the insolvency law.
I see. So Article 314 is for the preemptive strike. It's what you do in the dark before the legal spotlight turns on and the formal process starts.
That is a perfect way to visualize it. Article 314 covers the period when it's just you and the creditor fighting it out. Once the sheriff arrives and puts up the yellow "do not cross" tape, a whole different set of laws apply to your actions.
That is extremely helpful because I think a lot of people assume insolvency means I filed for bankruptcy. But this crime is specifically about the desperate, shady scrambling that happens before you file.
It's the cover-up before the official investigation even begins.
Wow. Okay, so let's zoom out. We have covered a massive amount of ground today.
Well, you certainly have.
We started with the basic concept of debt, that feeling of getting a bill in the mail. We learned that to be a criminal debtor, the debt can't just exist. It must be due and payable. You can't be arrested for a mortgage that isn't in default yet.
Right. And we learned that you don't need to be a merchant to commit the crime, although society and the law frowns more heavily on merchants who break that commercial trust, so the penalty is higher.
Then we got into the really weird part, absconding. It's not about running away to Mexico with a bag of cash. It's about making the property run away on paper. The sham sale.
Yeah.
The fictitious consideration, hiding a house in plain sight.
But, and this is so crucial, we learned about the no harm, no foul rule, the element of prejudice. If the creditor can still get their money from your other assets, your bank account, your stocks, your car, your fake sale of the house is just a waste of paper, not a crime under this article.
And we talked about the heart of the matter, malice. The guilty mind. You have to mean it. And if you pay even a little bit back to the creditor, it suggests you aren't malicious, just broke and trying to manage.
And finally, we saw that you can't be held liable for someone else's debt, not even your spouse's, under this law. And that this whole crime is about the shady stuff that happens before the bankruptcy court ever gets involved.
It's a fascinating collection of checks and balances. It really feels like the law is trying to thread a very fine needle. It wants to stop fraudsters, but it desperately does not want to criminalize every person who just makes a bad financial move in a panic.
That's the so what for the learner here. Why does this matter to you? It matters because it highlights that the law, at its best, values substance over form.
Say more about that. Substance over form.
Well, look at the absconding part. The form might be a valid-looking deed of sale. It has a notary stamp. It has signatures. It looks, for all the world, like a legitimate sale. That's the form. But the law looks past that, to the substance. Did money actually change hands? Was it a real transaction, or was it just theater? If it was theater, the law ignores the form and punishes the reality of what you did.
And it's the same with prejudice. The form might be, he lied to me about his assets, he tried to cheat me. But the substance the law cares about is, did you actually lose money as a result with no other way to get it back?
Exactly. The law is trying to be pragmatic. It cuts through the paperwork and the drama to see the actual economic impact. It's not about whether you were rude or deceitful in a vacuum. It's about whether your deceit caused a tangible loss that couldn't be fixed any other way.
That is a really comforting thought, actually, that the law is trying to find the reality, not just punish people for messing up the technicalities, although I guess the sham sale is a technicality that's been weaponized by the debtor.
It is. The fraudster tries to use form, the deed of sale, to hide the substance, which is the continued ownership. The law then counters by ignoring that form to find the substance.
It's the cat and mouse game again. The mouse builds a fake wall out of cardboard. The cat learns how to see through cardboard.
And the game continues. Forever.
Before we sign off, I want to leave our listener with a final thought to chew on. We've been talking this whole time about owning things. My house, my car, my land. But this whole discussion makes me wonder, do we really own anything?
That is a very provocative philosophical question.
I mean, think about it. If I can own a building, but then I sign a piece of paper that says you own it, but I still keep the keys and I still use it and collect the rent. Ownership seems less about the physical reality and more about a story we all agree to tell the courts.
It is a legal fiction in many ways. Ownership isn't a physical bond between you and a brick. It's a bundle of rights. The right to use it, the right to exclude other people from it, the right to sell it, the right to destroy it. When you engage in fraudulent insolvency, you are trying to unbundle those rights in a way the law doesn't allow.
You want to keep the right to use, but trade away the right to be seized by a creditor.
And the law says, nice try. They come as a package deal.
And here's another thought to mull over. We said that for the crime to exist, the creditor must be prejudiced, meaning they have no other recourse. They have to prove they couldn't find other assets to satisfy the debt.
Yes, the hunt for assets.
In today's digital world, where assets can be cryptocurrency in a cold wallet, or money in an offshore account, or ownership hidden behind 5 layers of shell companies, does this law still work? Or does that exhaustion of remedies rule actually make it too easy for a modern, sophisticated fraudster to get away with it?
That is the billion-dollar question, isn't it? Is the law, which was written for a world of physical property, too slow for the speed of modern finance? How much energy and money must a creditor spend finding your digital crumbs before they can claim they've been starved?
Exactly. At what point does the hunt for the assets become a form of prejudice in itself? The cost of finding the money might be more than the money itself.
That is a question for the courts, and perhaps for a philosopher.
Well, listener, we will leave you with that. Next time you sign a deed of sale, or borrow money, or just look at your house and think, that's mine. Remember Article 314, ownership is a responsibility, not just a privilege. And if you try to make it disappear, make sure you aren't just performing a magic trick that lands you in jail.
And maybe, just maybe, pay your debts when they're due. It's a lot simpler that way.
Sound advice. Thanks for diving in with us today.
A pleasure as always.
See you on the next Deep Dive.
Welcome to The Debate. Today we are walking a very, very fine line. It's the line that separates a business failure from an actual criminal act. We're looking at Article 314 of the Philippines Revised Penal Code. specifically the crime of fraudulent insolvency. And this is a topic that really forces us to ask a fundamental question about justice. Where is the boundary between simply being unable to pay a debt and actively committing a crime to avoid paying it?
It's a pleasure to be here. And that boundary you mentioned, I mean, it is incredibly blurry. We're looking at a statute that penalizes a debtor for how they handle their own property. But the real tension here, and what I think we need to unpack, is this conflict between, the spirit of the law and the letter of the law. Does the law care that you tried to cheat, or does it only care if you succeeded?
That is the central question we are debating today. Does the crime of fraudulent insolvency hinge primarily on the deceptive act of the debtor, what the law calls absconding, or does it depend strictly on the financial consequence to the creditor, what's known as actual prejudice?
That's the crux of it. And I come at it from a different angle. I believe the evolution of the law, particularly how the courts define absconding, suggests the legal system is, or at least it should be, focused on the intent to defraud, the malice of the act. The law should punish the mechanism of the fraud, not just the final math on the balance sheet.
And I see why you think that, but let me offer a different perspective. I take the position that Article 314 is a result-oriented statute. It's a crime of consequence. So regardless of how deceptive or slippery a debtor might be, if the creditor is not actually prejudiced, meaning if they can still get paid from other sources, there's no crime. The law isn't there to police morality, it's there to protect the satisfaction of the debt.
I suspect we're going to have a very interesting disagreement on what constitutes policing morality versus enforcing the law.
I expect nothing less. So let's lay out our positions a bit more clearly. My stance really grounded in the specific elements of Article 314. For a crime to exist here, strictly speaking, you need three things. 1, the offender is a debtor with due obligations. 2, they abscond with their property. And 3, and this is the crucial part, the offender's creditors must be prejudiced. And that third element is what I really want to hone in on.
The prejudice.
Yes. The jurisprudence, specifically in the case of People versus C.G. Seong, is incredibly clear on this. The court ruled that actual prejudice is required, not merely the intention to prejudice. We have to be very precise here. You can have a debtor who hides assets, who moves money around, who essentially acts like a scoundrel. But if that debtor possesses other property sufficient to satisfy the obligation, the courts have said there's no criminal liability under Article 314.
Which seems to imply that attempted fraud is perfectly legal as long as you're bad at it, or as long as you're too rich to fail.
I wouldn't frame it as legal, but rather not criminally liable under this specific article. It protects the legal system from being clogged with cases where the creditor hasn't actually lost anything tangible yet. If the money is there, use civil remedies to get it. Don't, call the police.
That's a compelling argument, but my position focuses on the conduct. The second element you mentioned, absconding, that's where the real story is. The law has expanded the definition of absconding so significantly, and I think that signals an intent to punish the behavior itself.
Expanded how, exactly?
Or physically conceal the property. It's not about geography. You can sit on your couch and abscond. And even more importantly, look at People versus Tandiang.
The case with the deed of sale.
Exactly. In Tandiang, the court held that even real property, immovable land, can be the subject of absconding if it's transferred to another person under a deed of sale with fictitious consideration. That is a massive shift. You can't physically run away with a plot of land. So the absconding here is the intellectual dishonesty. It's the creation of a sham transaction to place assets beyond the reach of creditors. That tells me the law is targeting the fraudulent nature of the transaction, the specific intent to cheat.
I agree that the definition of absconding has become more sophisticated, but I maintain that without the result, the actual prejudice, that sophisticated definition is, it's just academic.
Let's dig into this a bit. You're arguing that because the courts include paper crimes like fictitious deeds of sale, they care more about the lie than the money?
I am. If the law only cared about the money, absconding would just be defined as non-payment. But it's not. It's defined as a specific type of maneuvering. In Tandeon, a Supreme Court recognized that transferring land with a fake price tag is a way of absconding. It creates a legal smokescreen. I mean, why would the Supreme Court expand the definition to include these complex, white-collar maneuvers if they didn't intend to penalize the dishonesty itself?
That's an interesting point, though. I would frame it differently. The broad definition of absconding is a net. It's a wide net designed to catch various methods of hiding assets. However, just because you catch the fish doesn't mean you keep it. You still have to weigh it against the requirement of prejudice.
But doesn't that render the net useless?
Not at all. It means the law is adaptable. It acknowledges that you can hide a farm just as easily as you can hide a bag of gold, legally speaking. But, and this is the but that matters, even in Tan Diang, the context is that the assets were placed beyond the reach of creditors. If the debtor had 5 other farms that weren't hidden, and those farms were enough to pay the debt, I would argue that Siegel Xiong kicks in. The absconding happened, technically, but the crime did not complete because the prejudice was missing.
I'm sorry, but I just don't buy that interpretation as the final word. It feels like we are allowing a moral hazard. If we look at People versus Sishi Xiong, you're really basing your argument on the phrase, mere fraudulent concealment not sufficient.
That is the direct quote. Mere fraudulent concealment not sufficient if creditors may resort to other property with which to satisfy obligation due them. It is a high bar, and I think rightfully so. We're talking about potential jail time here.
But think about the practicality of that. A debtor acts with malice. They deliberately execute a fake deed of sale, a lie, to hide their most liquid or valuable asset. They get caught, and then they say, oh, don't worry, I have this other fast depreciating asset over here you can have instead. And under your interpretation, they just walk away without a criminal record?
They don't walk away scot-free. They still owe the debt. They still face civil suits. But they aren't criminals.
But they attempted a criminal act. They engaged in the mechanism of fraud. By prioritizing actual prejudice over the act itself, you are essentially telling debtors, go ahead and try to hide your assets. If you succeed, great. If you get caught, just pay up from your reserves and we'll call it even. It ignores the fraudulent in fraudulent insolvency.
I see the moral frustration there. But the law, particularly in property crimes, is often pragmatic. It's about restoring the balance. If the balance can be restored financially, the criminal law steps back. This brings us to malice, which you touched on. You view the sham sale as inherent malice.
Absolutely. I mean, a deed of sale with fictitious consideration, that is a calculated lie. There is no such thing as an accidental fictitious sale. That requires drafting, signing, notarizing. It's premeditated.
And yet, look at People versus de Guzman. This case directly addresses the role of malice and how it can be, well, neutralized. In Guzman, the defendant disposed of property, but, and this is key, he delivered a portion of the proceeds of the sale to the creditor.
A portion, not even the whole thing.
Correct, and the Court of Appeals held that this act, giving part of the money to the creditor, negatived the malice. It canceled it out. This reinforces my position that the crime is fundamentally about the money. If you are sharing the proceeds, even if the sale itself was perhaps done quietly or without permission, you aren't showing the malice required for fraudulent insolvency. The intent to defraud just dissolves when you start paying.
I find de Guzman to be an incredibly generous ruling for the debtor. It suggests that you can cure a poisoned apple by cutting off a slice and handing it over. But I admit, legally, it does support your result-oriented framework. It reduces malice to a function of payment history rather than a state of mind.
Precision in language is what saves us from tyranny, as they say. Malice in this context isn't just ill will, it's the specific intent to completely deny the creditor their due.
I want to pivot slightly to another aspect of People versus Tan Diang that I think highlights the rigidity of your position and perhaps the limitations of this law. We talked about the debtor, but what about the accomplices? In Tan Diang, the wife participated in these sham conveyances. She signed the papers. She helped hide the land.
Correct, but she was acquitted.
Exactly. She was acquitted. And why? Because the creditors who were being defrauded were her husband's creditors, not hers.
That is element A. The offender must be a debtor.
Right. But think about that. She actively participated in the fraud. She helped abscond with the property. But because she didn't personally owe the money, Article 314 couldn't touch her. This pushes back against the idea that the law is effectively policing the fraud itself. It's so hyper-specific to the debtor-creditor relationship that it lets a co-conspirator just walk away.
I see that as a strength of the statute, not a weakness. It proves that Article 314 is not a general anti-fraud law. We have other laws for swindling or estafa. Article 314 is a specific tool for a specific relationship, the debtor and the creditor. If you aren't the debtor, you cannot technically commit this specific crime of insolvency. It bounds the liability to the person who actually holds the obligation. It prevents the net from being cast too wide, catching family members who might just be doing what they are told.
That is a compelling argument, but I do worry it ignores the reality of how assets are hidden. Fraud is rarely a solo act. By strictly limiting element A to the named debtor, the law ignores the network of people often required to execute a fraudulent insolvency. It treats the debtor as an island, when in reality they are often part of an archipelago of deceit.
I like that image, the archipelago of deceit. But we must prosecute the island that owes the money. If we started prosecuting everyone who touched the assets, where would it stop? The notary? The clerk? The law must be precise. Let's briefly touch on the procedural context, because I think listeners might be confusing this with the general insolvency law.
Yes, that is a common point of confusion. We're discussing Article 314 of the Penal Code, which is distinct from a violation of the insolvency law itself.
And the distinction is mostly about timing, isn't it?
It is. The source material clarifies that there is no inconsistency between the two. The insolvency law applies to criminal acts committed after the institution of insolvency proceedings.
Exactly. Once the court has stepped in and said, okay, we are doing a bankruptcy proceeding, the insolvency law takes over. But Article 314 applies generally before that formal machinery starts. It covers the acts a debtor takes to avoid getting to that point or to sabotage their creditors before the courts get involved.
And we should probably mention the merchant distinction, just to be thorough.
A minor but important detail. Being a merchant is not an element of the crime.
Right, you don't have to be a business owner. You can be a regular individual.
However, if you are a merchant, the penalty is raised. The law expects a higher standard of conduct from people engaged in commerce.
Which again, that plays right into my view. Why raise the penalty for a merchant? Because a merchant knows better. Because the malice or the intent is presumed to be more sophisticated or more damaging to the public trust. It suggests the law does care about the character of the offender and the nature of the act.
Or simply that merchants have more complex debts, and their failure impacts the economy more. So the consequence, again, the prejudice, is viewed as more severe by the state.
Yeah, you have an answer for everything.
I try, but this brings us to the end of our analysis, and I think the lines are drawn quite clearly.
Indeed.
To summarize my perspective, fraudulent insolvency under Article 314 is strictly a crime of consequence. The jurisprudence we've discussed, Sigisiong, de Guzman, consistently points in one direction. The law prioritizes the satisfaction of the debt over the punishment of the deceit. The phrase, mere fraudulent concealment not sufficient, is the guiding star here. If there is no actual prejudice, if the creditor can still be paid from other assets, there is no crime. The law refuses to use the jailhouse as a collection agency for debts that are otherwise solvable.
And I remain unconvinced that the result should entirely eclipse the conduct. The evolution of absconding in Tanjiang and Chongqing-Lumbago shows a legal system that is trying to catch up with sophisticated dishonesty. The courts have recognized that signing a fake deed of sale is just as bad as running away with a suitcase of cash. By insisting on actual prejudice as a strict barrier, we risk ignoring the intent to place property beyond reach. The malice is in the act of hiding the asset, regardless of what else is in the bank account.
It's a classic tension between the utilitarian view, did anyone actually get hurt, and the deontological view, was the act itself wrong?
Exactly. And for the listener holding a promissory note right now, looking at a debtor who just sold their house to their cousin for a pittance, the difference is not academic at all.
No, it certainly isn't. And that is where we leave you today. Article 314 balances the harshness of criminal liability against the rights of creditors to get paid. Whether it strikes that balance correctly is something you'll have to decide for yourself. Thank you for joining the debate.
Thank you for listening.